My name is Mihir Taamneh. In 2017, Abdulkadir Musharrapov carried out a terrorist attack on the Reyna nightclub in Istanbul, Turkey, on behalf of ISIS. The attack killed 39 people, including my relative, Nours Al-Assaf. Under 18 U.S.C. Section 2333, United States nationals or their families who have been injured by acts of international terrorism may sue for damages. They may sue the terrorist organization who committed the act. And under Section 2333d2, they may also sue any person who aids and abets, by knowingly providing substantial assistance, or who conspires with the person who committed such an act of international terrorism. Therefore, my family is suing Twitter for aiding and abetting ISIS. Twitter knew that ISIS was using the platform, but failed to stop that use. Instead, Twitter's algorithms promoted terrorist content to its users, allowing ISIS to fundraise, spread its message, and plan attacks.
Allowing ISIS to use my platform, like any other user, does not mean I aided and abetted that terrorist act.
I'll be the judge of that. The question we will rule on today is whether Twitter's conduct constitutes aiding and abetting such that they can be held civilly liable for ISIS Reyna nightclub attack. And our answer is
no.
I concur.
What? How did you make that decision?
Well, we first looked at the text of the relevant statute, Section 2333d2, which imposes civil liability on any person who aids and abets, by knowingly providing substantial assistance, or who conspires with the person who committed such an act of international terrorism. This text raises two questions. First, what does it mean to aid and abet? We used the framework laid out in Halberstam v. Welch, under which aiding and abetting means consciously, voluntarily, and culpably participating in another's wrongdoing. This requires three elements. First, the party whom the defendant aids must perform a wrongful act that causes an injury. ISIS committed a wrongful, injury-causing act when it attacked the Reyna nightclub, so the first element is satisfied. Second, the defendant must be generally aware of their role as part of an overall illegal or tortious activity at the time that they provide the assistance. Twitter was aware that ISIS was using its platform to spread terrorism, so this element is satisfied. Third, the defendant must knowingly and substantially assist in the principal violation. We will return to whether Twitter's assistance was substantial after discussing the second question raised by the statute. What must Twitter have aided and abetted to be liable, ISIS in general or the Reyna nightclub attack specifically?
ISIS.
The nightclub attack.
That's right, Twitter. To be liable under this statute, you must have aided and abetted the act of international terrorism, not just whoever committed it. However, this does not mean that you must have known all the details of the terrorist plot. So, with that in mind, back to the question, did Twitter substantially assist ISIS Reyna nightclub attack, making them liable for aiding and abetting? We do not believe so. ISIS was simply allowed to use Twitter, just like any other user, and the algorithm recommended its content to users just like anyone else's content. This passive assistance does not rise to the level of active aiding and abetting. Notably, Taamneh does not claim that ISIS used Twitter to plan or coordinate the Reyna nightclub attack, nor that the attacker used Twitter at all. Twitter is no more culpable of aiding and abetting than a cell service provider whose phones were used to broker drug deals.
I agree. However, it is important to recognize that this decision is a narrow one. Different cases with different allegations and factual records may lead to different conclusions. And the principles we use to interpret this statute do not necessarily translate to other contexts. But today, Twitter will not be held liable for aiding and abetting the Reyna nightclub attack.
You rule, Supreme Court.
You suck, Supreme Court.